Thank you for joining us today on this video presentation of the path of Rule 20, a step-by-step process from arrest to restoration. We begin first with an allegation or accusation that a criminal statute has been broken. You have been arrested and have been booked for that crime. That does not mean a crime was actually committed, just that there are allegations and evidence that you have possibly committed a crime. The client then appears in court. Now, this is not just limited to the pleading. Rule 20 can be activated at any point when a client appears in court, whether it's for initial pleading, for an Alfred plea, which is the type of plea when a client recognizes the evidence against them is overwhelming. They are not admitting what they have done, but they are admitting that if it goes to trial, they will probably be found guilty, or at trial. Someone recognizes there is an issue with the client. It could be the prosecutor, it could be the defense counsel, it could be the court itself. There is something about the demeanor, there is something about the language, there is something about behavior that is causing a question as to whether or not the client is able to understand or provide for their own defense. The client cannot demonstratedly, rationally consult with counsel and or understand the proceedings or participate in their defense of the criminal charges made. At that point, someone makes a motion for a Rule 20 evaluation. The motion must contain facts, and the motion cannot breach client-attorney confidentiality. So if the defense attorney is bringing the motion, they have to be very careful in the way they do it to provide enough facts in the motion to the court requesting the Rule 20 evaluation that it also does not breach the confidentiality of the client and reveal any information that could impugn or in some way negatively impact the client. At that point, the criminal proceedings are suspended, because there is a suspicion that the client cannot participate in their own defense or they cannot consult with the defense counsel. There is no way to proceed forward on the criminal proceeding with one exception. Now, a motion is just a request that the court take an action. You can do a motion for literally anything you would like the court to order. For instance, as a juvenile attorney, I had a child who was in foster care, but that child had received ice cream for dessert at dinner every night. So I did a motion to the court requesting the court order that that child, while in his foster home, receive ice cream for dinner. That was my ice cream for dinner motion. It's just a request that the court take an action. The court now reviews that motion, the supporting arguments, and the facts, and then issues an order based on that request. The suspension of the criminal court proceeding is limited in that nothing else goes forward, but the judge will still do a probable cause finding. Probable cause means there is a reasonable basis that a crime may have been committed by the defendant. The reason that this is important, if probable cause is not found, the charges are dismissed and the court has no authority to move forward. The only way a criminal court can move, take motions, or take action on anything is if it has a case in front of them. And if there's no probable cause for the case, there's no case. And if no case, criminal court cannot take action. If there is probable cause, a Rule 20 examination will be ordered to take place within the next 60 days. If there is no probable cause, the court can still issue a judicial hold. So even though it doesn't have authority to move forward on the criminal charges, it can in fact order an individual be transported to a health facility if they are in danger of harming themselves or others, or failed to show for an examination or a commitment hearing on an emergency hold or a commitment petition is filed. Any one of those three occurrences can be grounds for a judge to order a judicial hold and that individual be transported to a health facility. If the motion for the Rule 20 is granted, it can be denied. There may not be a factual basis. There may not be a procedural basis, but if it is granted, then an examination and determination need to be made. The client can be released back to the community if the client is not a threat of harm to themselves or others, and the client has housing or supports in the community. An appearance at the Rule 20 examination is a condition of that release. The court may order the client be confined to a state hospital or other suitable facility for up to the 60 days it takes to complete the Rule 20 evaluation. If there's no hospital availability, there's no bed available in a hospital, or a hospital is not equipped to care or handle the client, they may stay in corrections. Evaluations are currently done on Mondays. There are approximately 750 evaluations being done a year. This means that approximately 15 evaluations are done every Monday for 50 weeks a year, figuring there's a week off for major holidays. This is one individual doing these evaluations. The written report from that evaluation that's due within 60 days, unless there's another order by the court, has these 7 factors. These 7 factors are critical not just to the court, but also to housing providers and care management in the community, in the hospital, or in corrections, because they will provide critical information not just about the client, but about the client's care and what it will take to restore them to competency. So that report will have a diagnosis, a differentiation between whether the client is mentally ill or cognitively impaired, the treatment required to attain or maintain competency if they go back to the community, a list of treatment programs and providers in the geographic area where they live. If they go to an institution, it has to have reasons why that person can't go back to the community. Determination if the client can ever attain competency, and if so, the estimated time required to attain that competency, factual basis for the diagnosis and these opinions, and if the client refuses to participate, which does happen, is that refusal due to a mental illness or to that cognitive impairment? The report can absolutely be challenged by anyone. This requires a separate hearing with the burden of proof being preponderance of the evidence. Now, there are 3 proofs that are used in court. The first, preponderance of the evidence, is the minimum standard. That means a judge just believes one side more than another by 0.0001%. One side has to prove its case to the judge slightly better. The judge has to believe one side slightly more than the other side. And if the client is found competent, then the criminal proceedings continue from that point. If the client is found incompetent to stand trial, this is a very narrow, very specific finding that comes from the Rule 20 evaluation. It applies simply to that moment in time in criminal court with regard to the charges brought forward. That is all the finding says. The criminal court will then order that the civil commitment process begin. That is a broader finding with regard to a more general, holistic approach to the client, because again, an incompetent to stand trial finding is simply just with regard to that moment in time. At that point, the criminal charges are either dismissed, suspended, or preserved. Misdemeanor charges are a criminal charge that carries less than 1 year in jail. These are minor crimes, usually statutory, with no victim. Trespass is a very common one. The misdemeanor charges at that point are dismissed. Criminal court no longer has a proceeding going before it. The charges are dismissed while it goes over to the civil court in order for a commitment hearing. Gross misdemeanors, so that is a larger misdemeanor, the penalty is less than 1 year of time in corrections, but it is a larger charge, or a felony. Any felony charge carries more than 1 year in prison. If the prosecutor does not file to preserve the charges, those gross misdemeanor charges can be dismissed after 30 days. Felonies other than murder can be dismissed after 3 years. If the prosecutor does file to preserve the charges, those charges continue suspended in criminal court until the client is restored to competency. There is misinformation on this out there that is unfortunate. People believe the first part as if it's fact, that, oh, if I have a gross demeanor charge, it's automatically going to go away after 30 days. Not the case. There are folks in the community who believe, oh, if I have a felony after 3 years, it's going to go away. So all I need to do is not be found restored to competency for 3 years, and then magically, poof, the charges go. This is absolutely 100% false. The prosecutor has to not only actively decide not to preserve the charges, but even then, it's only possible to be dismissed. No person who is appearing before criminal court should ever assume or think that the charges against them in criminal court have gone away. Expect that if criminal charges are brought, that those criminal charges are going to continue until the finding of competency. The second thing on this is, if you are found or accused later of a crime and come before the court, a finding of incompetency to stand trial on previous charges does not carry forward. It is specific to that incident. So if you have been brought before criminal court on charges of trespass and you were found incompetent to stand trial and those charges were dismissed, and 6 months later someone comes in and they are charged with trespass, it does not mean that automatically, oh, I'm incompetent to stand trial because I had a finding 6 months ago. No, each incident is unique to itself. The court does retain authority for the criminal charges, including bail and conditions of release, participation in any evaluations, participation in any civil court proceeding with regard to competency, participation in medication, participation in community services, whatever it might be. Those continue as criminal court orders. There is now an order for a pre-petition screening. Just because someone is found incompetent to stand trial with regard to charges does not mean they are generally incompetent or they are not able to function in the community. And the criminal court and the Rule 20 evaluation don't have the authority, the ability, and frankly don't want the authority or the ability to make larger findings with regard to someone. First, a pre-petition screening is performed by the designated agency in the county where either the criminal case is being heard or the home county for the client. While that pre-petition screening is being performed, the client needs to be in the least restrictive environment. If they are found that they cannot be put into the community and they cannot be put into the hospital, they need to remain in corrections. We should have, but do not have, but should have a jail-based competency treatment. This does not exist at this time. In order to be a jail-based competency treatment program, you have to have a medical licensed professional that can prescribe psychiatric medication. Psychiatric clients have to be housed separately from general population. It should appear to be more of a hospital or treatment facility than a detention facility. But ultimately, part of the problem is that Medicaid funds cannot be accessed under federal law to pay for treatment or medications for someone who is in corrections custody. So funding for a jail-based competency treatment cannot come from Medicaid funds. It would have to come from a separate funding source. So if they are currently being held in corrections and have been determined unsafe to return to the community, then they're going to go to a hospital within 48 hours, but actual admission time is based on hospital capacity. Client can be discharged from the hospital to the community if the client is restored to baseline and found not to be a threat to self or others. This is not a determination of return to competency with regard to the Rule 20 finding. This is a separate finding based on different mental health criteria. Can the person be safe in the community? This has nothing to do with an incompetent to stand trial finding with regard to those specific trials at that specific moment in criminal court. They're two very different things. And ultimately, a client who is found incompetent to stand trial on those charges because they cannot participate in their defense or they don't understand the charges being brought, most probably will go back to the community. It is the least restriction. There are more options for mental health treatment, substance abuse, and legal education. There is outpatient treatment, and it is less costly than hospitalization or corrections, with the ability to access Medicaid funds in this situation. The pre-petition screening for civil commitment, which has been ordered by the criminal court prior to the civil court being able to take anything on, will look at the entire client, what has been going on, what is happening in their current situation, and determine if there are grounds for a civil commitment. That recommendation is sent to the county attorney and the social services agency within 5 days of being ordered. At that point, the county attorney determines if there is a factual basis for this civil commitment. The county attorney knows the judge, knows the law, knows the proceeding, and knows the likelihood, based on the pre-petition screening being given to them, whether or not it will be successful in court. This is why there is an enormous amount of confusion in the community. A client will be found incompetent to stand trial. They know there's a Rule 20 finding, but then they're back in the community. There was a rumor about a civil commitment, but nothing was ever filed. So because nothing is filed, there's no proceeding, there's no finding, no orders. So it was really basically everything is based out of the criminal court, and now the client is back in the community doing their regular services with whatever orders the criminal court put in place. However, if the county attorney does feel that the pre-petition screening does rise to the level and does provide the factual basis for a civil commitment, a petition for a civil commitment will be filed. The commitment hearing itself has to happen within 5 days by request of the client, but the court can extend this to 10 days. Courts are very busy, calendars are very full, and sometimes you can't honor a request by the client within those 5 days. If the client does not request it, it's 14 days of the petition being filed, but again, this can be extended an additional 30 days by the court. This is done for a number of reasons, not the least of which is the client may be so close to the borderline of whether or not a commitment would be ordered that by providing an extra 30 days, the client may be restored and no longer meet the burden for being committed. They may be just fine and able to go back to the community. The examination and determination are completed. The standard for a civil commitment is clear and convincing. Now, as mentioned before, there are 3 standards. The first is preponderance of the evidence, 0.0001%. A judge just believes one side just that slightly more than the other. At the other end of the spectrum is beyond a reasonable doubt, the criminal standard. This is the standard we have used forever. Most people are familiar with it. It is that you cannot have a reasonable doubt based on the evidence that the client has actually committed the offense. For those that would like a great lesson on what this looks like, 12 Angry Men is possibly not just one of the greatest films in American history, but is a wonderful examination of what exactly beyond a reasonable doubt means. Between those 2 standards, preponderance of the evidence and beyond a reasonable doubt, is clear and convincing. Is the evidence clear? Can I look at the story told by the evidence and laid out? Is it convincing that, yes, this story told with this evidence convinces me that, yes, this is what happens? So if preponderance of the evidence is 50.01% and beyond a reasonable doubt is 90%, clear and convincing is between those two at about 75%. The finding has to show that the client is at risk of harm to themselves or to others, specifically due to being mentally ill, chemically dependent, developmentally disabled, mentally ill and dangerous, which is a separate finding, sexually psychopathic, or sexually dangerous. The reason it has to be risk of harm of self or others due to one of those categories is a person is capable of harming another person rationally, not because they suffer from something on that list, but just a rational, regular, average human being can be a risk of harm to themselves, and they can be a risk to others. So just because someone is threatening to kill someone, just because someone is threatening to harm someone, and just because someone is threatening to harm themselves, does not mean it is due to a mentally ill state. There's a substantial demonstrated likelihood they will physically harm themselves or others. And there is no less restrictive alternative than hospitalization. So they can't be in the community. If they're in the community, there is a demonstrated likelihood that they will hurt themselves or they will hurt someone else. And that risk comes from one of those 6 things. So it's a very specific finding, which is what the county attorney looks at when they get that pre-petition hearing. Are these things here? Is there a substantial likelihood they're going to harm themselves or others because of a mental illness, being chemically dependent, being developmentally disabled, being mentally ill and dangerous, being sexually psychopathic, or being sexually dangerous? And that is the case that the county attorney brings. While the civil court proceeding is going on, the criminal court does continue to review the status not less than once every 6 months. In other words, the minimum is 6 months. They can review it monthly. They can review it weekly. But the minimum, at least every 6 months, the criminal court has to review the status of what's going on. The reporting is done to the criminal court by either the head of the institution, the hospital, or wherever the client is, or the person charged with the client's supervision. Copies of that report go to the prosecutor and the public defender. The prosecutor must be notified of any proposed changes to the civil commitment and can participate in the civil proceeding. Client may have prior convictions and involvement with parole or probation, which involves a parole or probation officer into this proceeding. They have to be notified of what's going on in civil court, and they have the ability to participate if they choose as well. Once a commitment is heard, and if the judge feels that, yes, in fact, the standard has been met, there's a substantial likelihood this person will hurt themselves or others, and that harm comes from one of those 6 categories, and that there is no way they can be safe in the community, there are a number of different outcomes. The first is the client may have met that standard prior to the hearing. A week before the hearing, they were in that state. They were hospitalized. They were not taking medications appropriately. They were in whatever psychotic state they were in. But in between that moment in time where it was filed and the hearing itself, they've stabilized. They're okay. They can go back to the community. They would release that person before ordering a commitment because they may have met the standard before, but they don't now. They may be a continuance of the commitment for a dismissal. In other words, the client was impaired in that same situation. They're in the hospital. They weren't taking their medication appropriately. They're in a psychotic state, but they're engaged in the treatment. They're taking their medication appropriately. They're motivated to move on and is imminently restorable. The judge will continue it unless someone comes in by a date certain and says, nope, something happened. It will just automatically be dismissed. There is no commitment. The commitment hearing can be continued for 90 days after which it is dismissed. It met the statutory burden. However, they're doing better. They're participating. They're coming around. They're doing what they need to do, but it's not imminent. It's not going to be within the next few weeks. So the court will continue it for 90 days to give them that time without ordering a commitment. Because the person is voluntarily participating in their treatment, there's no need for a court to order anything. And it looks like within the next 90 days at some point, they're going to be restored through their own voluntary participation. So there is no need for them to be committed. The court can order the commitment stayed. Judges are on their bench and they write their order, and then it stays on the bench. It doesn't go into the file. It stays on the bench. The judge puts that order down on their desktop, essentially, and it stays there. It's signed. It's an order, but it's not put into place yet. This is, in its own way, a threat. Look, you meet the burden. You may or may not be participating. You may or may not want to, but if you don't, you seem at this point reasonable and open to participating. So I'm going to issue the order as the judge, and I'm going to just put it right here and leave it here. And I'm going to expect a report back. If you have decided that, yes, in fact, you want to voluntarily, of your own will, participate in your treatment, I'm not going to issue that commitment order because you have decided that you want to do it. You are doing it yourself. By signing the order and issuing the order, it's demonstrated to the client that, yes, the court is serious and we're going to do this. The time for goofing around is gone. Take this seriously. The client may be motivated to now do it on their own, so that order is stayed. If the client does not participate, then the order can be put into place and the conditions of the civil commitment go forward. The order is for 9 months. However, because criminal court gets a 6-month review, it is traditionally changed to 6 months. So while statutorily the commitment order is 9 months, it is actually 6 months. And within 6 months, the court will bring everything back in to say, how are we doing? Where are we at? Is this individual complying with their treatment plan? Are they complying with the orders of the court? Are they doing what they need to do in order to be? And if not, it can be renewed again for an additional 12 months. There is the commitment review. Again, the civil court reviews every 6 months. The update goes to the criminal court, and the review can be requested by a client at any time. If a client feels that, you know what, I want to do this, I want to participate, I'm participating, I'm much better, I'm doing what needs to be done, and I'm good to go, they can go and request that the court review it at that time. And if they have met the standard, if they're participating, if there's no need for a commitment any longer, the civil court can end that civil commitment. So Rule 20 competency restoration is a separate thing from civil commitment. Again, it's just incompetent to stand trial with regard to those charges. That is reviewed every 6 months. The goal is mental health restoration. It is not the civil commitment standard. Competency education is involved, and again, that reevaluation is done every 6 months to see if they understand the charges that are brought and can they participate in their defense. That are the two most important factors with regard to ending the Rule 20 order with restoring competency. Can they participate in their defense? Do they understand the charges being brought? So while someone is on a Rule 20 finding, whether they're civilly committed or not, whether they're in the hospital, they're in corrections, or they're in the community, that is the only thing that a Rule 20 incompetent to stand trial finding means, is they did not at that point in time understand the charges brought against them, and they were not able to participate in their own defense. They may have been sent to the hospital, but again, the hospital has its own standing. If they're stabilized and no longer a threat to self or others, they're discharged to the community. They may not meet the criteria for the civil commitment. They may be civilly committed in the community, but there's no restoration programs. These are called gap cases. Essentially, there is nothing going on that is assisting the client to move forward toward restoration. There's no orders from a civil court. They are no longer seeing services to the hospital. And despite the report that was found with regard to Rule 20, which recommended the services needed in the community, whatever that person needed to be doing, orders may not have been issued, and that person just took them as a suggestion, and they're just in the community. So we have what are called gap cases, where these folks have a finding, but there is nothing going on to move them towards restoration. This video is brought to you by Ramsey County Social Services and was made possible by a Mental Health Innovations grant. Thank you.